Thanks, Ron. I like those Mitchell jokes better. In a very condensed time frame, I'm going to talk about something that affects a number of folks in their organizations in the audience. Those of you in the private sector can maybe breathe a sigh of relief that you don't have to cope with this. Government intervention. In the broader public sector, historically, if we go back to the early 2000s, the funder, the provincial government, typically would impose an overall mandate, but it wouldn't be micromanagement. Leave aside the runaway freight trains that continue to occur with the police, fire, and whatnot in essential services interest arbitration. In education, for example, bargaining was done board by board. Trustees were at the table, they were elected, and the costing was directly related for the settlement to the increase in your municipal tax rate. As the provincial government then started to assert more and more control on program and funding, the bargaining became much different. We also then started to hear the buzzwords of austerity, and in the paper that Brian, my colleague in the London office, prepared, and you'll hear Brian later, he talks about some of the public sector restraint pieces of legislation, starting with Bill 16, and then moving on to Bill 55. And what is a bit remarkable about those pieces of legislation is that there was the adoption or recognition of a creature called the non-union bargaining group. And if you were a group of managers, and this was quite common, is quite common in larger, broader public sector organizations, if you bargained loosely, collectively with your employer, you were therefore exempt from the restrictions and prohibitions, much like a union would be, resulting in the strange situation that in many organizations where there were thousands of employees, only the CEO, CAO, or director were actually caught. That didn't get a lot of critical attention because, frankly, the media didn't understand it. You ask why this sort of soft approach? Well, Brian's paper talks about the BC litigation, and that weighs heavily on the provincial senior executive in the government and their lawyers, and they are quite astute on the constitutional law. BC, with runaway costs in healthcare and education, tried a fairly aggressive approach and passed Bill 28 a number of years back that restricted what could be bargained at the table, for example, with teachers. That legislation was designed to curb the runaway expenditures, and the BC courts declared it unconstitutional as a breach of the Charter rights guarantee of freedom of association. 12 months later, the BC government, after smarting from that decision, introduced Bill 22, which provided for essentially the same potential restrictions, but after some good faith consultation. And the teaching federations took that legislation to the courts, and the result was the same, declared unconstitutional. And to add insult to injury, in the decision in January of 2014, the BC Supreme Court punished the provincial government for its aggressive behavior with a damages award for enacting legislative action in Bill 22. And at least now we know the license fee amount. there were 30-some thousand members of the Federation that appealed Bill 22, and the damages were $2 million, and the court concluded $66 per member was the right number, which would strike me as a bit of an invitation to continue the round robin of legislation if that's all it costs. But so our provincial governments, senior bureaucrats, say what you will, we can all complain, but they have some very astute folks, and they are worried about being overly intrusive. So we came with Bill 115, which attracted a lot of scrutiny, and the government was trying to get rid of the unfunded liability that existed at about half the boards on sick leave, retirement gratuity payouts when you retire, and imposed freezes, and essentially there was the very real presence of the gray ghost at the bargaining table some years back, and the government was able to convince the Catholic Teachers Union to agree to a memorandum, and that then became sort of the, I guess, the model for Bill 115, and it was essentially foisted on other players in the education sector. Adult supervision sometimes is a bit misguided, and it's a little bit like me giving supervision to my kids on computers. I don't know the foggiest thing about them, but the provincial government, as one small example in the back in the Bill 115 days, decided to impose certain measures that would allow for the senior supply or casual or occasional teachers to get a preference to the permanent jobs. Now, I imagine many of you have friends, children who are wanting to be teachers, and they're on the supply list, and the way it works is you go out and impress the local principal, and you're ready to respond in a moment's notice, and ultimately that serves you well, and you'll probably in 2 or 3 years get a permanent job opening, subject to whether you're in a declining board or not. Well, essentially now the system gives seniority to the occasionals. So if you think about it, the longer you're on the supply list says what? You're maybe not the most attractive candidate. And my kids are out of school now, so I don't have to worry unduly about the future constituency, but that will be populated by those who didn't get on before. So it's that type of approach that worries us. So now we have Bill 122, which until yesterday was, it was sort of waiting in the wings. There's a few folks in the audience that have been doing the prep work, and Bill 122 now establishes this unique model of three-party bargaining. The government, a employer bargaining agency, and trade unions, and you'll have a bunch of tables going on. And the government has to okay any deal, and central items are negotiated there, and then you go back to the local municipality and bargain locals. Well, the first thing, having done some main table bargaining in the private sector, is what's a main table item and what's a local item, and that is going to have to quickly get resolved. It won't get settled, in my view, and the legislation dictates it goes to the OLRB that considers factors such as whether or not it would impact education at one or more boards, and on and on. So you will hear a lot about the acrimony. The Labor Board will be entertaining some of these cases, and then we will see how heavy-handed or intrusive the Crown is going to be. Now, the Crown will have read some statements by the BC courts, which are not technically binding on Ontario legislators, but which do recognize that so long as you are setting some parameters for fiscal responsibility and you're not just drawing a bright line, that's not supposed to be viewed as a breach of the freedom of association. But we can expect, I'm sure, some challenges in Ontario if the result doesn't please some of our particularly the teaching federations. And whether or not a majority government will now give, I guess, a stronger mandate to its members at this three-handed game remains to be seen. And I think at some point we'll hear from those that will be going through this to see what kind of unholy alliances develop in a three-handed game with your tax dollars. Ron, thank you very much.